then that's really very critical to them.
Sure. Well, we're happy to be here tonight and talking to all of you. I'm Christine Porter. I'm an attorney with the Allegheny County Public Defender's Office of the Public Defender, and I have here Laura McWilliams, who's the managing attorney there, and Allison Ware, an assistant public defender. And I think Laura is going to start off, but I'll tell you a little bit about myself, and then we can maybe all of us introduce ourselves. So I work on an education advocacy project within the juvenile division, and that's where the three of us are. And I've only been there since February. It's a project that's funded by the Heinz Foundation, and we try to provide, education support to the clients that are within the delinquency system. So I don't know, Laura, do you want to introduce yourself?
Sure. So my name is Laura McWilliams. I'm really happy to be here. I've been a public defender in Pittsburgh for about 8.5 years. I've been working with just in the juvenile division with children for about 6 of that. And the more I work in the juvenile system, the more it becomes clear how much disability can affect things that happen in the court system. And it's become clear that I think supportive community members are really don't know what to do and are really confused. So I'm really happy that we could connect with you guys and hopefully give you some information that you can find useful. And Allison, do you want to go?
Sure. So my name is Allison Ware, and I'm an assistant public defender. I am also on a grant-funded project by the Pittsburgh Foundation, and I am handling summary citations for our office. So any juvenile who is charged with a summary comes through me. And so we're handling those at all of the magistrates and trying to also help raise awareness to the impact of disability, like Laura was saying, Christine was saying, on those charges and how often kids can get charged for a disability related, behavior or incident. So.
Okay. All right. So, I have in getting to know people in the disability community, it has come to my attention that you guys are really scared of when the police get involved. So we want to, my goal as a public defender is to talk to you about police encounters and what the court system will look like. So when the worst thing happens, children with autism in trouble with the police. So the first thing is police stops, which I think is the next slide. Okay, so police encounters are a tricky thing. And most people don't know what to do when they get involved with police. So the first thing about when police stop you on the street is you don't have to give them any other information other than, kids don't have to give any information other than their name and their date of birth. The law is kind of weird on this. They don't really even have to give that unless they're under investigation, but it makes things go easier, I think, if kids are just willing to give their name, sometimes date of birth, parents' name and number, so they have a person to call. Sometimes they ask the kid what school they go to, sometimes they don't, sometimes they ask their address, sometimes they don't. But the important thing to keep in mind with police encounters is that, like, especially for kids who are going to be extraordinarily uncomfortable in this situation, is to not do any, this is a horrible thing to say because the police should be responsible for everyone's safety, right? But I have to tell kids to be really careful not to do anything that is going to upset the police. So that means, as much as possible, no sudden movements, no putting your hands in your pockets. And that's why I say it's just easier to give your name, date of birth, and your parents' phone number so that they just call your parents and get it over with as quickly as possible. So you want to end the encounter as quickly as possible. And usually the best way to do that is to give your name, date of birth, and phone number, parents' phone number. You don't have to give them any other information besides that, and you shouldn't, and I'll get to that in a minute. Running from police is one of the worst ideas ever. I don't have to tell that to you guys because everybody knows, but when kids run from police, that's when trouble happens. Police will chase them. They don't let kids just run. They will chase them. They will try to stop them. The law allows them to, for the most part, chase down a kid who just runs away without any provocation. So don't run, and be prepared for a police stop ahead of time. So know what to do when police stop you. Don't give up any, and I'll get to this in a minute, but don't give up any incriminating information or even anything that you think might be innocent information, because you don't know what kind of crime they're investigating. The other thing that I think people are not always clear on is that it is entirely legal to record police in public. Something that people ask me sometimes is, what can I do if I see someone get stopped? Well, one of the best things you can do is record it if you can, if it's safe to do so. Stay your distance, record the encounter so that I, as their attorney, have evidence to prove the police, if the police did something wrong during the stop, then that's recorded. If it's in a public space, it isn't 100% legal to record police. And I always tell kids, if they tell you to put away your phone, you probably want to do that, because how much is your phone worth to you? If police are telling you to put away your phone, that's not legal. But I've seen police destroy people's phones when they wouldn't turn them off. Like, I've seen it happen, and phones are very expensive, and it's not worth it to lose your phone. So those are the basics when police on the street stop someone: name, date of birth, parents' name, phone number, and that's all you have to give. Police searches outside of school. So if a child or an adult, if anyone is stopped by police, you never have to consent to a search. You never have to say, it's okay to search my car, it's okay to search my house, it's okay to search my backpack, it's okay to put your hands in my pocket. You never have to give that permission, and you shouldn't, because you have a right to your privacy. As soon as you give police permission to search, they don't have to follow the law anymore. And the law says that they can't search unless they have reason to think a crime is occurring. They can't pat you down unless they think you're armed and dangerous. So a crime is occurring and you're armed and dangerous, or you consent. Those are the only ways that police can legally search you. If they search you and it's an illegal search and they violated those rules, then I can fight it in court. And they find something illegal, and you get charged with it. But they searched you illegally and you did not consent, I can fight it in court. But as soon as you said, okay, it's okay, if they say, can I search you? And you say yes, I can't fight it anymore, because you agreed to let them search you. Officers can pat someone down if they have reason to think the person is armed and dangerous. A pat down is your outer clothing, so they can't be reaching into pockets. They can't be going into your backpack. They can't be opening up your coat and searching inside your coat. A frisk, a pat down is just a pat down of your outer clothing. I always tell my clients, because anytime I meet a new client, I tell them what their rights are when police stop them. Never fight a police officer who's trying to search you, but remember all the details of how they did it so that you can tell your attorney. Because if you can tell me the details, if you can tell me that that officer opened up my jacket and reached into my inside pocket and found something there, then I can try to fight your case in court. But if you don't remember that stuff, and I understand that it's really traumatic to be searched by police, but do the best you can to remember all of the details. Police also very often have body camera now. So if you tell me that this happened during the search, I can get the body camera and see what happened, and we can try to fight it in court. So the main thing is you never have to consent to a search of anything, and you shouldn't, because you have a right to your privacy. Police don't automatically have a right to search you just because they're police officers. Okay, next slide. And then that leads me to questioning, police questioning. So this is advice for adults and juveniles. The law is the same for the most part for adult. I see someone's asking, is this for adults or juveniles? This is all across the board. Adults and juveniles have, for the most part, the same constitutional rights. So speaking to police, so I get calls from parents because police want to talk to their child about something that may or may not have happened. And the parents ask me, what do I do? Do I have to take my kid in to talk to the police? The answer is no. You never have to go in and talk to police. So I'm going to talk, there's two different ways that police question someone. The first is just they encounter someone on the street and they're asking them questions. Same thing, you don't have to give anything up. You don't have to give them information. But the second way is either they arrest you and take you into an interrogation room, or they ask a parent, for kids, to bring in their child and meet with them and talk to them. And I think parents, maybe not this group, but I think a lot of times parents think that like truth is the best, truth will set you free. If you did it, you need to own up to it. And I always say, you need to be honest with yourself and your higher power and probably your mom, but not the police officers, because when police want to bring, so I want to step back and talk about when police want to question a child. So separate from an arrest, if police make that phone call and say, I want to talk to your child about this thing that happened. The first thing is, this is an actual picture of an actual interrogation room. This is what an interrogation room looks like. There's different variations of this. They're usually this size or smaller. Sometimes they're in basements. Usually they have the kid sitting there by themselves for a bit of time. Usually with kids, they try to bring the parent in, but not always. This is a screenshot from an actual interrogation of an autistic child that from a few years ago. He's the one with his arms folded. This was a case where they called the parent, asked the parent to bring him in. The parent thought he was doing the right thing, and the kid went in. They spent about 10 minutes talking to the dad about the kid's rights, that he doesn't have to speak to police, that he has a right to an attorney. And then the dad said, it's okay, I'm willing to have him talk to you. And then after that was the first time they talked to the kid, and the kid basically admitted that he did the thing they were not exactly the thing they were accusing him of. But without his confession, they didn't have a case, and nothing ever would have been filed if he hadn't been taken into the police station. So this is why you should never agree to speak to police, because they either have enough to charge you with the crime, or they're trying to get enough to charge you with the crime. You can't talk your way out of charges being filed. It doesn't happen. They're trying to make their lives easier by having a kid come in, or an adult, because this is true for adults too, come in and confess. Because as soon as a person has confessed, that almost closes the case for them. So they're trying to make their lives easier. They're trying to get a confession so that the case is much easier to win when it comes to court. People worry about, well, if I don't go and talk to police, they're going to think I'm guilty. So what? That's not evidence that you can use in court. You can't use in court as evidence that this individual did not come and talk to police. I had recently, something happened in a local school district outside of Pittsburgh, where the school officials encouraged kids to come forward if they've ever experienced sort of like an unwanted touching. And so all of these kids came forward and reported old incidents to their guidance counselor. And I started getting I had a bunch of parents call me and ask, do I bring my kid in to talk to police? 3 of the parents I talked to had boys who were autistic. And I told all 3 of them, don't talk to police. They're either going to charge your son or they're not. And all 3 parents did not take their children in to talk to police, and 2 of the cases never got filed. So they didn't have enough evidence to justify charging the kid to begin with. And the case just went away. And the 3rd one, I think charges were filed, but without a confession. So it's a lot harder to prove a case without a confession. So that's why you should never talk to police. You never know what they're investigating. You don't know what information they have. Police can lie to you, and they will. All they're trying to do is make their lives easier by getting a confession from a suspect. You really cannot talk your way out of a police, out of criminal charges. You can only talk your way into them. So when police are questioning you, so this is when your Miranda rights attach. So everybody knows your right to remain silent and your right to an attorney. That only applies, it doesn't apply when you're arrested. It applies when you're being when you're arrested and you're being questioned. So you have the right to remain silent. You have the right to an attorney. Usually when you say, I want my attorney, the reason I put right in, like, I don't know what those little wiggly lines are, is because they don't usually, when you say, I want my attorney, they usually just stop questioning you because it's way too hard. But once an attorney comes in, the attorney is going to say, stop talking. So as soon as someone says, I want my attorney, they're not going to wait for the attorney. They're just going to save themselves some time and stop questioning the person. Children are supposed to have the right to consult with an interested adult. That means a parent, a guardian, a family member, someone who's interested in the outcome before they agree to talk to police. So that's something that's different with children. Children are supposed to have a right to talk to a parent or guardian about whether they want to talk to police. This is another interrogation room from an actual interrogation. The kid, who's the kid in yellow, was in this room for about an hour by himself. And you can, when I'm watching it on the video, so they called his mom. His mom is the woman with the yellow hair. So they called his mom while they were waiting for his mom. They had him locked in this interrogation room, and you can see him getting more and more agitated. He's like pacing, he's taking his clothes on, his like his sweatshirt on and off, he's head down, head up, he's really, really nervous. By the time police come in, he just wanted it to be over, so he told them everything. And I don't actually remember what happened with this case, but I do remember the interrogation, how incredibly coercive it was, just making a child sit there by him in this basement room, locked in there for an hour by himself. Just how scary that is for a kid. So the key words are, you say you want a lawyer, or I do not wish to speak to you. You have a right to remain silent, but the weird thing about, in the United States, we follow the Constitution as defined by different courts. And the courts have said that you have a right to remain silent, but it's not enough to remain silent. You actually have to say it out loud that you don't want to say anything. And if you don't say, I don't want to talk to you, you have not invoked your right to remain silent. And you may have to repeat it. You may have to say it more than once, because police are going to pretend like they stopped the interrogation. They're going to come back in and check with you again and see if you really do want to talk to them. So you may have to say it more than once. Ideally for children, the once is enough. And for the most part, especially for autistic kids, police tend to be, for what I've seen, pretty good about respecting. I'm distracted by the chat. I'm going to get to you guys' questions in a minute about nonverbal. So police tend to be very good at respecting children and children's refusal to speak to them. And when a kid has autism and they know it, sometimes, so I've seen both ways. I've seen them take advantage of it, and I've seen them, police officers, be very respectful of that. And it kind of depends on the police officer. Now, for a nonverbal person, this is going to be different, because it's going to be really hard. This is maybe not a question that I can answer, because I have never represented a nonverbal client, because someone who's nonverbal does not have an ability to communicate with their attorney, so they're not competent to stand trial. So it's really hard to, it's very, very difficult to file charges against someone who's nonverbal. It's hard. So I don't know how they would signal, other than if they have a card on them, that they're nonverbal. So I don't have the answer to that question, and I've never represented a nonverbal individual. I saw a question: should you tell police that you're autistic? I think I'm going to let Christine answer that. I don't know the answer to that question. I'm going to see if Christine has an answer.
I think so. You should definitely tell your attorney.
Yes.
But yeah, I don't see why not. I think the police should know. I don't think it's always going to be obvious to the police. So I absolutely think police should know.
Yeah, and I'm just thinking, so part of the, if I'm in court and I'm arguing that a confession with police was coerced or wasn't given voluntarily, it comes down to sort of like the person's individual circumstances. And if police knew that the person had autism and continued to press them anyway, it's going to make my argument that the individual was coerced even stronger, because they knew they had autism and took advantage of it. So yeah, I think it probably is helpful to let someone know you have autism. Also, police, I think, are getting better trained at working with individuals with autism. So I just, in general, for safety reasons, I think it's a probably good practice to tell the police that someone has autism. So ideally they've been trained and they understand what's happening if there's a meltdown or if there's something like that. Okay, let's see, next slide. Okay, so arrest, when can a child be arrested? So I think some of you maybe already know this, but a child can only be charged with a crime if they're 10 years old or older. It's different for summary offenses, and Allison will get to that. But for a juvenile delinquency charge, a criminal charge, you have to be 10 years or older. Setting aside homicide, so murder is its own separate thing. You could be charged at age 6. I mean, it would be really hard to try a 6-year-old for murder, but you could. So homicide is its own separate charge. But to arrest and charge a child, they have to be 10 years of age or older. I have never represented a 10-year-old because 10-year-olds tend not to be what we call competent, which is mature enough to understand what's going on, able to assist in their own defense, and able to communicate with their attorney. So generally those kids are just too young to prosecute. And the chart, I don't think I've ever even gotten a case with it where a 10-year-old was charged. Usually they're 11 or 12, and even then is pretty young to charge someone. So between ages 10 and 18, or until your 18th birthday, you generally go to juvenile court, except for certain offenses, which I'll get to in a minute. So when a charge is filed against a child, that goes to juvenile court until the day of their 18th birthday. Act 33 is a law in Pennsylvania that allows children ages 15 or older to be charged as an adult if they commit certain offenses, which is basically violent felonies. So armed robberies is usually what we see. Those kids can be charged as an adult. Generally speaking, at least my experience with autistic clients is that those are not the crimes those kids are being charged with. Kids with the kiddos I represent who have autism, it's like a very specific set of offenses. It's either property damage, assault, or a sex-based offense. Those are sort of the three types of, it's not limited to that, but I don't tend to see autistic kids committing necessarily violent felonies. It's usually a reaction to something that's going on or boundary difficulties. So as soon as you're arrested, you want to get a lawyer. In Pittsburgh, our public defender's office is the best at juvenile court. I know that that's not necessarily true for all of the counties, but in Allegheny County, we are the best at what we do, and we're really pretty good. We try to be really good at working with kids with disabilities, and we're always learning, and we're always interested in hearing from parents. So when you get an attorney, just make sure, whoever it is, make sure that you let the attorney know that there's a disability, any disabilities, all of them. All of that stuff is really important to know. Okay, so what happens if someone's detained? So when a kid is on the street and arrested, they could be detained. When a kid, so like the story I told of these kids who are being investigated for these old sex-based offenses, even from a week before or a month before or a year before, those kids tend not to be arrested. Those kids tend not to be picked up and taken to a detention facility. At least in Allegheny County. I don't know how it is across the rest of the state, but in Allegheny County, older offense, the only reason you would detain a kid is if they're a danger to the community or if they're a flight risk. So if the offense happened a month ago or 2 months ago or 6 months ago, they're not a danger to the community. So it's hard to justify detaining a kid for an old offense. If they get into trouble and they're kind of arrested on the scene, kids can be detained, meaning held at a detention facility. In Pennsylvania, the law says when you're arrested and taken to detention, you have a right to a detention hearing within 3 days. This is across Pennsylvania. This is not just Allegheny County. Within 72 hours, you are supposed to be in front of a hearing officer or a judge who decides if you stay in detention. And then after that, every 10 days, if you're still detained, if you're still in a detention facility prior to being found guilty of something, every 10 days, you go back in front of that judge, and the judge has to keep making that decision until either something happens with the case or the kid is released, and then something will happen with the case. How will my kid get an attorney? So in Pennsylvania, all children are considered indigent, and so all children qualify for representation from the public defender's office in whatever county you live in. So the law in Pennsylvania, so public defenders are provided for people who cannot afford an attorney. In Pennsylvania, the law says all children cannot afford an attorney just by statute. They're considered indigent. They qualify for services through the public defender's office. Every county does it differently. In Allegheny County, the probation officer will give the parents information about the public defender's office and who to call. I know that also if you're looking for a private attorney, you can call the local bar association to get recommendations. Again, not every county has as robust of a public defender's office as we do. So some of the outlying counties, I've heard some stories about things. But in Allegheny County, we're really good at what we do, but you don't have to go with the public defender's office. You can pay for a private attorney. You want to get an attorney as soon as possible so that you have assistance through this process. Okay, so working with your child's defense attorney. So the first thing to know is that when a child is charged with a crime, that child is, so when I'm representing a kid charged with a crime, the kid is my client, and I'm required by the ethics of my job and by statute to do what the child wants, not what the parents want, not what the probation officer wants, not what the judge wants, not even what's in the best interest for the child. I'm required to do what the child wants. Now, I will counsel the child and try to get him or her to think through the options. And like, ideally, we're coming up with a solution that is in their best interest. But at the end of the day, the child is my client. So my practice is to talk to the parents as long as I have permission from the child. But my client is my main is my main source of contact, unless the kid struggles with understanding or struggles with communication, and then with the kid's permission, I will involve the parents. I will meet with the kid in the presence of their parents. I think sometimes parents and family members are the best source of information. So I always, one of the best things you can do when your kid is charged with a crime is make sure that the attorney, whoever is your child's attorney, knows that the kid has whatever specific disabilities that the kid has. So autism is a really important diagnosis for us to know, because it can affect their competency and the ability for them to be prosecuted. Autism has this really incredible ability to remain hidden sometimes, and especially during COVID times when we're not as in person as I would like. I don't have the same kind of interactions with my clients that I did when COVID wasn't around. So when parents can give me that information about any kind of treatment that's being provided for the kiddo, any kind of diagnoses or mental health issues that I need to know about, any other disabilities, all that stuff is really important for a kid's attorney to know. Even an adult attorney needs to know that stuff, and should be aware of it when working with someone. I think also family members and community members can be really helpful at helping me gather evidence, because kids are not great. Just kids in general are not great historians. They're not great at thinking through who would be a good witness, what kind of evidence do I need to fight the case, who else would have been there, what is what is happening in the history that would give someone motivation to lie about something. All of that stuff I can get from parents, that kids aren't necessarily thinking through all of that kind of stuff, because they're just not sophisticated enough to be thinking through it. So you can help your kid's attorney by helping sort of investigate the case and thinking through what witnesses there might be, or what other evidence might be out there that the kid maybe isn't, my client is not giving me the information. Parents are a really good resource. I usually, my practice is to try to talk to the parents before I talk to the kid. If I'm interviewing the kid on the phone. If I'm doing it in person, I like to meet with the family together and then meet with my client separately, just to build some trust. But I always appreciate working with the family members of my clients, because you guys can give me so much information that I wouldn't otherwise get. Okay, so I'm going to go over the court process. I can go over it pretty briefly. When kids are charged with a crime, there's certain outcomes that can happen. So if a kid is charged with a sort of a minor offense, there's something called an informal adjustment, and that's diversion. That means it's diverted away from the court system. So charges are just never filed in juvenile court, and the kid is allowed to do some kind of community service or some kind of sometimes mediation if there was a fight at school, sometimes mediation with the other kid if the kid's okay with it. If it's like the kiddo stole a candy bar or stole something small, they pay it back, do some community service and work it off, and then the charge never has to come to court. Parents get really scared about this because what happens is a probation officer calls the house or calls a parent and says, I want to meet with you and your kid. I want to talk to them about this thing that we think they did, that they're charged with. And it feels, I can understand that it feels very weird because you're doing it without an attorney. And I just told you guys never to let your kid admit to anything to law enforcement. But the tricky thing about informal adjustments and diversion is that nothing the kid says can be used against them. So if they are offered, like, you do 10 hours of community service and this goes away, and they don't do the community service and charges get filed against them, they can't use any statements that the kid made during the informal adjustment process against him. So it feels very weird because you're taking your kid to meet with a probation officer when they have not been found guilty of anything, but it's a really good way to keep the case out of the court system. And that should be your main goal. Your main goal should be to keep your kid away from a judge and keep your kid out of the system because, and Christine will touch on this a little bit later, but once the system gets involved, you lose control over what happens to your own child. You lose control over what happens in your house, in your family, and most importantly, with your child's life. You can lose control over that really fast. It can spin out of control really fast. So you want to do everything you can to try to keep a case out of the court system. So the next thing is if a case is not, if no informal adjustment is offered, in juvenile court, it's called the juvenile petition. In criminal court, it's criminal information or criminal complaint. In juvenile court, it's a juvenile petition. It's just different words that we use. That's the actual filing document that charges a kid with a crime. As soon as that's filed, you should be calling to get an attorney. As soon as you know that there is something has hit the court system, you should be contacting an attorney and getting your representation for your child. In Pennsylvania, children are not supposed to proceed without an attorney. Nothing in court should ever happen without an attorney when there's a child involved. And I just recently got statistics from across Pennsylvania for juvenile court. And in 2020, which is the most recent year when statistics were available, 0 juvenile cases went forward without an attorney. Every child was represented, which is amazing. So it's gone down over the years, and that's because kids were doing things that was not right and was not legal, and kids were being sent away without an attorney representing them. And so Pennsylvania, and that happened in Pennsylvania, that's the Kids for Cash scandal. Some of you may have heard of it. That was happening against parents' wishes, against kids' wishes, and kids were just being sent away without attorneys there to represent them. So now in Pennsylvania, kids have to be represented by attorney, and you should not waive no case should go forward without an attorney. Every child should have, every adult should also have an attorney, but definitely every child needs an attorney to guide you through the process. There can be, once charges are filed, there can be something offered called a consent decree, which is basically a chance for the kid to work off whatever they did. It's a period of probation, basically. If they do everything that they're supposed to do in 6 months or a year, the case goes away, it gets wiped off the record. It's like it never happened. Those are offered for not for serious offenses, but for most juvenile offenses, setting aside sex-based offenses, a consent decree is offered for the first time a kid gets in trouble. It's a chance to prove that you made a childhood mistake and this shouldn't mess up the rest of your life. It's a chance to get it wiped off your record. And then you have, if that's not offered, you can go to trial, you can take a plea offer. In juvenile court, it's not enough that you committed a crime in Pennsylvania. You also, a child, so when an adult is charged with a crime and they're convicted, you're just sentenced, it's punishment. In juvenile court, the child, not only, it has to be, there's 2 separate findings. First, that the kid committed a crime. Second, the kid is in need of treatment, supervision, and rehabilitation from the court system. So any information that you can give your kid's attorney about the services they're receiving outside of the court system can help me make the argument that they don't need anything from this court. And I mean, in Pittsburgh, it's a really hard argument to make. I don't think I've ever won it, even though I've made the argument many times that this kid doesn't need any more services, already receiving all the services they need. But I know it is successful in other counties. And that is an adjudication, which is the same thing as a conviction. Disposition is the same thing as sentencing. So this is why you don't want your kid involved in the court system, because as soon as a kid is found guilty of something or admits to having committed a crime in juvenile court, they're under supervision. And that means every mistake that they make is under a microscope. So it really robs kids of the ability to make mistakes. Even something as small as missing a day of school can get your kid removed from the home and get them sent to placement. If they miss a day of school, 2 days of school, if they get into a fight at school while they're on probation, any of those things can end with your child being taken out of your home, and you won't have any say over it. Because it's not true that you won't have any say. You won't have the final say over it. A judge will have the final say over what happens to your child. So when a kid is found guilty of something in juvenile court, they can be placed on probation, or they can be taken out of your home and sent to a treatment facility, which is really one of the worst things that can happen to kids, and is very traumatic for the family and the child. It interrupts normal adolescent development. It's incredibly traumatic for kids with disabilities. And so that in a nutshell, that last line, probation and juvenile, those last two things, probation and juvenile placement, that's why you don't want the courts involved, because you lose control over what happens with your own child. Okay. Parents calling police. I'm going to let Christine talk about this one.
Okay. So Laura was just talking about parents losing control over what happens to their child. And that's sometimes what happens when parents call the police for help. And I just want to say, I should have said this before, but I have 2 autistic children myself. Someone was saying at the beginning that police were called to their house because their child was screaming. That has happened to me before. This is personal to me. I worry about it with my own children. So I understand how parents, can feel like they need to make this call. And we just want to warn you, be careful, that this really should be kind of the last resort when you feel like there is no other option, because of what can happen. Sometimes what we see happen is, police, the child is dysregulated. The parents call for help. Maybe the police come, there could be, there could be aggravated assault charges then involved, right? And then your child has felony charges, and that can be true even if that child was in crisis at the time, right? So this is how some kids get into the system when parents were really just calling for help, and it's coming from a good place. They're seeking this help for their child, but if there are other options, try those first. In Allegheny County, you can call Resolve. That should be the number for Resolve. Even that, I'm a little hesitant because there can still be law enforcement contact, but at least that way, it's more likely that your child will receive the help that's needed, that the child will receive that help, and that there'll be less confusion about like why you're calling. And we know there need to be more options. It's clear there need to be more options. And if any of you know of more, put them in the chat, and we're happy to talk about those and share those out. I sometimes hear from people, especially people who work in schools, but I hear this all the time, that it would be helpful for some children to be adjudicated delinquent, because that's a good way to get the child the help that he or she needs. And that is not true. That is a complete myth. I'm not aware of, appropriate mental health services that are available through the delinquency system that can't be obtained outside that system. If anyone knows of those, let me know, but I'm not aware of any. Do we need more? community-based services? Yes. Are the wait lists too long? Yes. Will having your child adjudicated delinquent help with that? No. You know, if a parent is listening to this and, you know, then you probably already have you have some connections already, right? You know, you can call Autism Connection, you can call Achieva, we can give you, you can call us and we'll try to connect you with someone who can help. But I know, you know, in that moment of crisis, it may be hard to know what to do, and you can just be careful if you're calling the police. So I think Laura's going to talk about police in school now.
Okay, I just wanted to add one other thing that it is also true. So it was really interesting having Christine come on with her own personal experience onto our team, because I really learned a lot about the myths that I wasn't aware of that existed. It is true that having an adjudication of delinquency on your juvenile record can actually prevent you from getting some services, depending on what the charge is. It can make it harder to get treatment. We have kids all the time who need to go to a residential treatment facility, maybe need to, and they can't get into one because they have a juvenile charge on their record that was either violent or I don't even know, or sometimes fires can prevent facilities from taking kids, like all kinds of, or even just a report of the kid has a history of setting fires, and now they have this adjudication for a simple assault, which is a misdemeanor. That those two things together can keep a kid out of a treatment facility. It actually prevents kids from getting treatment. I've seen it prevent kids from getting treatment that they need. So it's your juvenile record, and it shouldn't matter, right? You're a juvenile, your child, but it still counts against these kids. School police. So this is really important because kids spend so much of their lives in school, and so many schools have police officers in them. There is a different, when you're in school, when a kid is in school, they have a different expectation of privacy. That means police have a different kind of right to search kids. They don't have to have the same standard of proof that all they have to do, they have to have, it's called reasonable suspicion. They have a reason to believe the kid is either breaking the law or violating a school policy, and they can search the kid or their locker or their belongings. But they're still police officers. If they're going to question your child, Miranda still applies. So your child has a right to refuse to speak to a school police officer the same way they do a police officer on the street. And I know that it's more complicated because they see that police officer every single day. There's a different kind of relationship, and there's a different kind of relationship with the school. But it's the same theory that if they're questioning your child, and you guys, probably everybody listening already knows this, but if they're questioning your child in the school, the kid does not have to answer the questions, and probably shouldn't, because same reason, they're either going to charge the kid or they're not, and anything the kid says is just going to make it easier for them to be charged with a crime. They're not going to be able to talk themselves out of a criminal charge. It's just not a thing that can happen. Yeah, so Miranda still applies. Okay. So the police or school officials can search a kid's locker. I've had it happen all the time where the kid comes into school smelling like marijuana. That can be enough to let the school police or teacher or any official in the school search the kid. It can sometimes be enough to if a kid smells like marijuana and has a lot of money on them one day, that can be enough to search their locker, search their backpack, because there's a suspicion that they're dealing drugs in school. The law says that's just, those things can be enough. So the short version of this is your kids should not take anything illegal to school. You guys already know this, but definitely if there's any place you shouldn't have something illegal, it's in school, because it's going to get found and you're going to get charged with a crime, and I don't have a good way of beating it. Okay, I'm gonna let Christine talk.
So just to continue this, even though this isn't a talk really about school discipline, given the amount of police contact in schools these days, we really have to think about the ways school discipline and police contact in schools are connected, right? And that this is one of the main contributors to the school to prison pipeline. this increased police contact in schools. You know, and here's what happens sometimes, right? The school views the child as having some behavioral mental health challenges in the classroom, and the school will initiate discipline or otherwise try to push out that student, right? And instead of providing behavioral interventions, instead of bringing in a BCBA or behavioral experts, we see schools frequently resorting to police to manage behavior. And, you know, some schools, they clearly don't have the staff that they need and they're desperate. And, you know, it's understandable that they're trying to get more resources in however they can, but whatever the reason and whatever the intention, it's harming children. And, you know, calling the police for a child struggling with behavior in the classroom without providing additional supports, that's just about as far from a free and appropriate public education as you can get, right? So thinking about how these things come together, you know, we have a lot of parents calling us about suspensions, expulsions, and often there are charges that are also filed, right? So for the same incident that the school is, the school discipline is about, there's also charges that'll be filed. Sometimes parents don't know that those charges are coming. So it's important to really think about that if your child is suspended. And, you know, these are just some, I think we'll just run through these really quickly, but, you know, there are procedural requirements if your child's suspended. There's no such thing as an indefinite suspension, a long-term suspension beyond 10 days in Pennsylvania. A suspension that's online education. These are not things. So after 3 days of suspension, the school has to have, and this is IEP or not, the school has to have an informal suspension hearing. And, you know, when you go into this hearing, which is usually just kind of a meeting with the principal and some people, if the child is there, I always tell the child, if I'm representing that child, I tell the child, don't say anything in this meeting, right? We're just gonna listen to what everyone else has to say. The child has the right, the representative has the right, parent has the right to question any witnesses that are there in that meeting, to see the statements. You know, you can get the evidence, talk about what happened, but I say, don't say anything. And then we can find out usually either before that meeting or at that meeting if charges were filed. And often those are, you know, sometimes that's summary charges, and Allison will talk more about that. But that way, because any statements that are made could be used against that child later. And, you know, so, and just thinking about that, you know, just, I'm sure everybody is probably aware, but Pennsylvania law is more protective than federal law for students with intellectual disabilities. So there are extra protections that kick in even, you know, with 1 day. So you can't just suspend students with intellectual disabilities without, there has to be more process. So yeah, so expulsions, you know, that's anything beyond 10 consecutive school days. That's an expulsion. You have to have a formal hearing. But remembering, you know, thinking about how charges might be coming, that those hearings are recorded and any statements made could be used against a student. So really thinking about, you know, trying to get an attorney for that hearing. If you're a parent, you're with your child, should your child really be testifying in this hearing, right? Knowing that the statements could be made, could be used against them. And this is for any student, of course, IEP or not. You know, we also have in Pennsylvania disciplinary transfers to alternative education placements, and there are extra protections for those too. Knowing that the extra for students with disabilities, but there still has to be due process provided before any student can be pushed out to another school. So the IEP, so before we all probably know that before a student can be expelled, they'd have to have a manifestation determination meeting. So that's for anything beyond 10 days or 15 days in one school year. So a lot of the students, I go to these meetings, and this is sometimes they'll try to combine it with that informal suspension hearing. So you'll be in a meeting, it feels like an IEP meeting, and usually the whole IEP team is there, and they'll talk about what happened and try to determine whether it's a manifestation of that child's disability. And just remembering that this can be done as a hypothetical, right? So the student doesn't have to admit anything in this meeting. Nobody has to admit that this actually happened. You can just say, if it did, would this be a manifestation? It's a little bit awkward, but it's a safer way to do it. And schools get this. I haven't had any yet question, approaching it as a hypothetical. And in these meetings, you also still want to be careful of student statements. So I say that same thing, just sit next to me, just listen. And then if we need to, we take a break in the meeting, and the student tells me what they need to tell me, or maybe writes it down and hands it to me in a note. So what's the next slide, Allison? Oh, this is just more of, so I hear a lot in these meetings that, the question about, well, what if this isn't a manifestation of their disability because they know right from wrong, or, they intended to do it. And that's not the standard, right? The standard was that behavior related, caused by, or directly related to the disability? And then we also have to look at, was the IEP followed? So if if the behavior was related to disability, or if the IEP was not followed, then that the child can't be expelled for that behavior. However, there can still be charges coming for that incident. So yeah, so this is the same thing about maybe best not to make any statements in these school disciplinary hearings, which are these meetings and informal hearing. These are going to happen before anything with the court system happens. So the school discipline just moves so much faster. And, just realizing that, of course, courts are not the right venue to address special education issues, right? I think our judges are trying to understand more about education and IEPs, and we have made a lot of progress in Pennsylvania, I think, but there's a whole system set, but we have the IDEA for a reason, and that's when we should be addressing these issues. We shouldn't be addressing them in court. So yeah, it's important to get copies of everything. If there are manifestation determination worksheets, the FBAs that are done after school referrals to police often will really be kind of an explanation of what happened from the school's perspective. And sometimes those end up conflicting with other documents that are provided. So I think it's really important to get everything, records about a search, who was there, what happened, especially if your child doesn't remember or was traumatized, or is for whatever reason unable to communicate that to you. This may be some really helpful information might be in the records, and get those and give them to your child's attorney. So yeah, and remembering that with pushing students out of school for behavioral incidents, that there are stay put or pendency rights, and that schools can't just do this unilaterally when there are manifestations of disability, but that because of that, some schools are turning to the juvenile justice system to try to both manage the behavior and to try to push out these students in a way that they can't do using the IDEA. So yeah, restraint in school, I think part of the way this is connected is realizing that mechanical restraints, handcuffs are a form of restraint. And if there are restraints, and there could be other kinds of restraints associated with the incidents that might lead a child into the court system, that there could be issues with this, that your child might not be receiving a free and appropriate public education if they're being restrained, at school and they're multiple times and there's no plan in place. And that if their child is restrained, there's supposed to be an IEP meeting. You're supposed to come up with a new plan to address that behavior. And some of that, those records, some of what's happening there, getting new services in place, that could also be helpful in a court case. So, like we said, school discipline moves more quickly, and after school referrals to police, the students are supposed to have an updated, so you'll need to meet as a team, and there'll be an updated functional behavior assessment and an updated positive behavior support plan. So addressing whatever went on. I don't see this happen very often. I don't see the IEP meetings after restraint. I'm not seeing this happen either with any fidelity. So it's just something to be aware of, and another place where more support could be added for that child. Oh, and this is Allison.
Okay, so I handle for our office any child who comes in with a summary citation. So felonies and misdemeanors are handled by Laura in our juvenile division, and then any summary offense I am handling with their support. So it's not just me doing it, they're there too. But so what if your kid gets a summary citation? So if your child, we don't know, like Christina and Laura both mentioned, if when your child is stopped or if when your child is questioned by school police, we don't always know what the charge will be. So in many circumstances, Christine has met with families who said, my child's being suspended for, they're accused of fighting in school. Well, we don't know if they're charged with disorderly conduct, which is a summary offense, or if they're charged with simple assault or aggravated assault. And so we don't want them to confess. We don't want your child to confess to anyone for any reason, whether it's disorderly conduct or aggravated assault. Confessing, like Laura said, is bad news for us in the end because we can't pull it back, right? So I just today where the child admitted to something to the school when they pulled him into the office. Well, I really had no defense left because they had my client admitting to the thing. So it's best to just say, I don't have anything to say. You can go ahead and file the charge or call my mom or do whatever you need to do, but I have nothing to say. The citation will come in the mail. This throws off a lot of people. It shows up like a speeding ticket or even less flashy looking than that. So a lot of people miss it. They say, I didn't know I got it. So just if you think something happened to your child, just be on the lookout for it. People miss it all the time. And something that's a little bit different about summary citations is you will not go before a common pleas judge. Any families who are involved in their community, you might know who the local magistrate is. So at least in Allegheny County, this is how these work. I can't speak for every other county, but in Allegheny, you go before the local magistrate. So in your little town, your borough, township, that's where we go for the case. It's not at the big courthouse. It is important to share your child's diagnosis, treatment, therapy, any supports that are in place. At the magistrate level, it is a huge, huge help. So typically when we go to resolve one of these cases or go to a hearing, it's super important to that judge, what is this child already doing? Because in many cases, they will give the child community service or, do an anger management class, or many judges up here really love this teen accountability program. Or I just have children who do mental health treatment. So anything that your child's already in is a huge help, both in that court system and to prevent them from getting some other type of repercussion. So some common examples of summaries are disorderly conduct, harassment, retail theft, criminal mischief, and truancy. So truancy is a big one that we see come through for our kids who are involved both in the juvenile justice system or just at the local magistrate. Schools will file charges if your child does not attend school. They usually file around day 10. They can file on day 6. So 3 days is truant, 6 days is habitually truant, which then gives them the authority to file. Contrary to what schools will tell you, they do not have to file. They will tell you that it's mandatory and they don't have to file, but that's okay. They try. And so those cases are a big one of what supports is your child receiving, what's preventing them from getting to school, what can we do to help them. And so this next one, I don't know why I can't. Oh, there it is. Okay, so this is an example of a summary citation for a client. So it is my personal recommendation that you at least consult an attorney if your child receives a summary. I know that our office is doing them. I know that not every office, fortunately, has a grant or capacity for it. But I think that sometimes at least consulting with somebody who's been in front of a judge can be helpful, and who maybe has seen one of these before. So this is actually, as Laura said, we typically don't get kids younger than 12 or 13, but this child that the example is of is 10 years old. He was accused of spraying silly string onto a neighbor's car. The neighbor called the police. This really did happen. We didn't make this up. The neighbor called the police and the police cited him for disorderly conduct. The silly string there was silly string on the woman's car, but nobody really could say who got it there, and it wiped right off. So rest assured, this woman is not out, paint on her car or anything of the sort. But these things can happen, and so not to scare anybody, but sometimes when as Christine was saying, whenever you call the police for trying to just break up something or get kids to go home, these charges can result. So just to run through it briefly, your child's name will be at the top. It's hard I know that we've blacked out a lot of this. Child's name at the top, your name as a parent will be on it. Your child will give the name and your phone number to be notified. They will give this description down here in the box, which sometimes doesn't always have a description. Sometimes it lists what disorderly conduct means or what harassment means. So you may not even really know what the citation is. And if your child either doesn't remember or, is unable to tell you, it sometimes can be difficult before you get to trial to know what's going on. And then at the bottom, there's just any victim information or anybody that they would need to reach. So then we have some tips in the event that you're, going to navigate this in your family, without consulting an attorney. Always plead not guilty. Even if you watched your child do whatever the thing is that they're accused of doing, always plead not guilty, because it gets you in front of a hearing officer, it gets you in front of the magistrate, and in many, many cases, at least in Allegheny County, I can speak, they do not want to find kids guilty. They want to find a way, because if you plead guilty, there's a fine associated. And then your child has something on their record and you owe this money to the court and it's just a mess. So if you plead not guilty, it gets you in front of that magistrate and it gives an opportunity for, something else to be done. And in many cases, because summary offenses are the lowest level of charge that you can be given, sometimes police or school officials, wherever it originated, are a little bit less diligent, I'll say, in sending the appropriate people to the hearing. So I often show up to hearings where, the school officials will come and they have no statement from anybody, but they come and say, we got information that this fight occurred or that this child we thought had weed, but they didn't bring anybody who was actually there. And so they can't convict your child on that. We also get, police where kids were, allegedly fighting in the street. And the police will say, well, we got a call from, Miss Johnson, but Miss Johnson's not here. But by the time we were there, the fight was broken, but we cited them anyway. Well, they can't find your child guilty if not the right people are there and nobody saw what was going on. So if you just plead guilty because your kid was honest and came home, like Laura said, and was honest with their mom or dad, they honestly get a little bit lackadaisical in who they bring. So never plead guilty. Do not pay the fine listed on the citation. Sometimes some magistrates, this is also the difficult part, every magistrate runs their courtroom differently. So I can't speak to what your particular magistrate will be in any given place, but they often list those fines just as an example, they call them. And so then if you plead guilty, the magistrate will assess you a fine that you are unaware of based on just what the officer wrote. So if they say, the child set a trash can on fire, that's a real case that I had. The child said, I was near people who set the trash can on fire. I don't even know them. But if he had pled guilty, a magistrate could have looked at that and said, well, that really could have hurt somebody and could have fined him a lot of money. But he came and said, I didn't know them. And we went through his whole story. And so he didn't have to go through any of that. Your child cannot be placed on probation, detained, or sent to placement. So differently than juvenile court charges, I always say the worst that can happen to your child is they have to pay a fine. They might have something on their record, but typically what will result is community service, a treatment program such as like the teen accountability class that I mentioned, or we have like a smoke-free class up here if your child, had a vape pen or something like that. And we find that in a lot of these cases, if your child has a disability, or if, your child is autistic and there's something about their behavior that is the result of their disability, we're working really, really hard to have that be part of the story. At the magistrates, it's a lot less formal. It's a little bit more of a conversation. And I had to learn early on that when the judge asks to talk to my client, I sort of have to let them. I never wanted to allow that, but they do it in a way that they try to holistically understand the child. And so explaining that your child has a diagnosis, explaining that your child is receiving treatment or therapy or is in particular programs at school to help them, all of that becomes very relevant at the magistrate, and many will hear from that. And so just as a last thought, if the case doesn't go how you want, you go in front of a magistrate, they were having a grumpy day, they find your child guilty, they fine you a bunch of money, you can always appeal it within 30 days. There's a form in Allegheny County that you fill out. So something that I say to my clients very regularly is nothing that happens here is final. We can work to undo it. We get another shot. And so we just really, it's a balance between recognizing the importance and recognizing that, you don't want anything on your record, whether it's a disorderly conduct or a retail theft or any of that, but also recognizing that at the end of the day, this charge cannot take you out of your home. It cannot place you on true probation. But you also are still at the mercy of a court. So we really want to try to make sure that everyone is properly supported when they go through that, if they would have to. So I think the last slide is just our contact information. If you need anything else. And then I think that's all that we have. So if either want to jump in.
That was a lot. It was really, really, really important stuff. So I'm wondering about people on the call, either we have kids or we help people who have kids. If they're really concerned that something's really brewing, that they might run into issues with the law, like, I guess, what kind of advice would you have? I have in the past asked young people to meet with an attorney ahead of time to get to know them a little bit and sort of like familiarize yourself. And sometimes they've been able to listen to that person as a neutral party that says, don't ever do this again, whatever that would be. Like, what's an intervention, diversion, deflection step that people might want to think about?
Let me think. So I've had parents call me and they say, I think a court case is coming, but really that's limited to police want to talk to my child. And then I will, on their behalf, I will call the police call the detective and say, I advised this kid's parents not to, I'll be the bad guy. And I will say, like, I talked to them. I told them not to bring the kid in. This is on me. I'm a public defender. Other than that, I can't represent someone who's not charged with a crime. I'm sure private attorneys would sit down and consult with someone. But I'm assuming you also would have to pay for that. That being said, I talk to parents all the time, and my contact information is up there when there's a pending court cases about what to do and what not to do. And usually, if there's one theme from our presentation, it's like, don't talk about the court case. So that's what I have.
The other thing I wanted to mention too, and this is more from my work with adults, when they end up at a detention, at a jail, because it's not a detention facility, there's really no question about, do you have autism? Do you have intellectual disability? So I'm not sure across the state if people would even ask. I trust no one anymore. I trust you guys. System wise, I just think that my opinion would be to get that out there in front constantly and wave that flag if you can, but maybe there's reasons not to. I don't know.
This is Kate, if I could just say something. I do know that we have just started doing, today I did the first of some county prison trainings. They're really excited to get that done, which is amazing. And the Office of Developmental Program is working with the state correctional institution, because Albion is going to be a correctional institution where they're going to take autistic individuals, and they're working on using, I think it's called the Autism Quotient. It's like a self-assessment. So it's a screening tool, but it will at least allow those individuals to kind of get those red flags to maybe know. I mean, because when we did it, we did a full-blown training for the entire Department of Corrections, like supervisory staff, and their number, I think at the time they said they had 17 autistic people in the state correctional institutions, which we all know is unbelievably laughable, right? But it's, they don't know. But on the other hand, I know I personally, as a mom, want my kid to say, if he's stopped by police, I have autism, just so you know. He wears an autism different, not less bracelet. So if his language doesn't come to point to that. But some of our autistic self-advocates have said that's not, in that situation, that might be the last place they want to share that diagnosis. If they've been teased, picked on, bullied as a result of being different, now they're in this really scary situation. What if this person treats me the same way? Which is why we're trying to train those officers, corrections, police, whatever, to ask that question, because then maybe that will make that autistic person think, wow, you know, they know something about autism. Maybe this is a safe place for me to share it. So just something to think about. And again, a lot of our self-advocates have expressed, you know, some of their concern about sharing that diagnosis. Everybody's unique and different though, but this has been amazing. Thank you so much. I'm so excited. We do a lot of trainings for autistic individuals, and I always take a local police officer with me. So this was great to kind of hear, you know, kind of what to do and not to do. But I love what you, you know, you public defenders have added to making sure we talk to them. We always do talk about not saying too much, not, you know, admitting to anything, but gave a lot of food for thought. So this was amazing. So thank you. And thank you for the work that you do too, day in and day out.
Mm-hmm.